All right, able. Dealing the matter of Carey Street Investments Ltd. and another, and Brown and another,
Mr. Parker.
My lord, my lady, I'm afraid I burdened you with a very additional bundle. It's quite slim. It's a short note in response to Lord Justice Newey's questions to how we saw tax evasion as a dishonest breach of fiduciary duty by the director.
I haven't looked at this obviously, and I'm sure it will be very helpful. Can I just, so I'm absolutely clear where the land lies, can I run through a hypothetical scenario with you and see where we get to, which is quite similar to the one I put to you yesterday, but goes a bit further. So suppose that you have a solvent company which owns a property for which two valuations have been obtained. And suppose that for whatever reason, the parent company wants the property to be transferred to it for the lower figure. Leave tax out of it for the moment. Suppose that it is the personal view of the director of the subsidiary that the true market value is a bit higher than the lower valuation. But he goes along with what the parent has asked. Now, as I understand it, subject to what's in this, he necessarily commits a breach of duty on your case.
Yes.
Is it the case that on an armitage and nurse basis, he is necessarily dishonest?
Yes. Subject to ratification.
So let's come to that, and that's obviously what you're addressing in here. Is it open to the director to say that the transfer was authorised or ratified by the parent?
Sorry, on the position as you just outlined.
Yes. So suppose you have property subject, which has been the subject of two valuations. It's being transferred at the lower valuation. The director himself thinks that the true value is a bit higher than the lower valuation. Is that capable of ratification?
Yes.
Because
there's no dishonesty. Sorry, I appreciate this is contradicting what I've just said, but in Armitage and Nurse, I began yesterday morning by saying I think it's relevant to consider the two aspects of dishonesty. Now, section 21(1)(a) in my submission clearly covers breaches of duty that are dishonest in what I call the layman's terms. It's just objectively dishonest without any consideration of the niceties of corporate law. Then there's a second form of dishonesty which requires an understanding as to the nature of the duties owed by companies. And that's Armitage and Nurse, and investigates the nature of the fiduciary duty, and it concludes that a conscious preferring of interests other than those of the beneficiaries is dishonesty for the purposes of section 21(1)(a). So when I answered the question previously to say that it was a dishonest breach of fiduciary duty, it's dishonest in the Armitage and Nurse sense. But for purposes of ratification, you can ratify a breach of fiduciary that is dishonest in the Armitage and Nurse sense, but you can't ratify a breach of duty that is dishonest in the Ivy and Genting sense.
yes, I see. And then,
And if I may, just pause
yes,
there.
please.
For the reason why I say it's a breach of fiduciary duty is, of course, my submission yesterday that you have to, the benefit has to be to the shareholder, qua shareholder. And using the language, and this is picked up in our note, using the language of section 172 of codification of the existing duties, the duty is to act in the way he considers in good faith would be most likely to promote the success of the company for the benefit of its members. So you have to promote the success of the company as a way of benefiting the members. You can't act contrary. You can't do something that isn't promoting the success of the company, but is nonetheless for the benefit of the members in their wider capacity. So obviously the facts of this case, the positive benefit is to the shareholder, not qua shareholder, but as transferee. And that makes it a breach of fiduciary duty. And because you're conscious of the facts, that means that in terms of the success of the company of which you're director, you shouldn't be doing it. It makes it a conscious breach, which is dishonest in the Armitage and Nurse sense. But it can be ratified because it's not dishonest in the Ivy and Getting sense.
I mean, I'm not surprised by the way you're putting that in terms of how you explained it yesterday. Can I just take it a stage further? I was looking at the pleadings. In the pleadings, you plead, I think, at least as your main point, that the alleged breach of duty was incapable of ratification because it was an unlawful distribution of capital. And you say there's an unlawful distribution of capital incapable of ratification where the price is known or suspected to be less than market value.
We do also say no ratification because it's dishonest, it's tax evasion.
So is reliance placed on the proposition that on the facts found by the judge, there was an unlawful distribution in relation to the transfers of the properties? We submitted it's sufficient for unlawful distribution to suspect that the transfer is at an undervalue, which of course is what the judge found. That proposition wasn't accepted, but Mr. Norbury did accept that if the director had blind eye knowledge that the transfer was at an undervalue, then that's an unlawful distribution. And obviously that feeds into my submissions yesterday that we say the judge should have found and had all the necessary ingredients to find and nothing else to stop such a finding of blind eye knowledge. Now, potentially this just sows confusion, not least because obviously what matters to an extent is what has happened so far in the proceedings. But in the hope that I might get slightly clearer in my own mind, I was just looking at Gower. If you want the particular paragraphs I was looking at for future reference, it's 18 hyphen 16 through to 18 hyphen 20.
I'll remember it well.
Where there's discussion about unlawful distributions, and there's reference to Aveling Barford and then progress property. And at common law, because of Aveling Barford, there arose a concern that where companies within a group transferred properties at book value, as is apparently said to have been common, they could be vulnerable. And the 2006 Act then does something about that. But going back to the common law, it isn't obvious, looking at progress property, or maybe, I don't know, it isn't obvious that wherever you transfer property at less than market value, you have a disguised distribution. And it isn't necessarily obvious, to me at least, that even supposing that you do, that's incapable of ratification if there are in fact distributable profits. And my impression is that this company, well, CSI at least, had large distributable profits at the time of the transfer.
No, it didn't. The solvency question, my lord, on the position on solvency is that in terms of the technicalities of accounting, it probably was insolvent. The solvency arises in terms of honesty, dishonesty, because the directors had the benefit of the share subscription agreement.
Sorry, so can we just take CSI?
Yes, go.
You're just going to discover that I don't have a proper grasp of the facts, but on the face of it, you established distributable profits by looking at accounts.
Yes.
And is it right that the last accounts showed sizable profits.
Not sure that's right. Maybe the last accounts.
We don't have the interim accounts, they were never found.
I mean, obviously, in terms of the distribution, because of the transfer of the value, it depends on the size of the.
I mean, in the event, it's said to have been £200,000. So if the company had distributable profits of £200,000, it would not be an unlawful distribution.
Pardon my ignorance, it's probably, we should proceed on the basis it did then, yes.
So the question then arises, if you undertake what might be said to be a disguised distribution in circumstances where you have sufficient distributable profits, is that incapable of ratification?
It is incapable of ratification, yes. It's our submission and our understanding of the law. I don't believe it's queried that the shareholders cannot informally do what is required to be done formally in accordance with the statutory requirements.
And I can't remember what the statutory requirements were in 2005.
Sorry. Oh, yes, yes. The statutory provisions that we were relying on for the purpose of our claim are in the authorities bundle. It's the fourth bundle. Chapter 21.
In section 263, there have to be profits available for the purpose. And section 270, you have to look at the accounts. And the last accounts were, I don't know for what year.
The last accounts will be the 2003 accounts because the 2004 accounts were signed off in September 2005.
So you'd have to look at whether the 2003 accounts disclosed distributable profits of more than 200,000 on this theory.
Yes, we do have. We probably got the figures for 2003 accounts because we have the 2004 accounts. Yes, it's in our additional bundle at tab 50.
Yeah. I'd have to check exactly what the statute requires, but it certainly has a large balance sheet net asset figure.
But my lord, in terms of ratification, is it not the case that you actually do have to consciously ratify rather than in the position it could have been ratified if it wasn't? And in the circumstances of a dividend, you have to consider the question, actively consider the question as to whether there's distributable profits.
I've only in the last few moments been looking at Gower, so I'm really not haven't got to the bottom of all this. But if you have companies within groups transferring properties at book value quite regularly, then the sorts of propositions you're putting forward are very alarming to them, albeit that, of course, the law has changed since 2007, was it, when the 2006 Act came in?
But not because. Well, perhaps I should have clarified. I did, in our pleadings, the submission is there that if you suspect that it's a transfer at an undervalue, it's an unlawful distribution. As I say, that wasn't accepted, but it was accepted if you had blind eye knowledge, it's an unlawful distribution.
So if you have
And
blind
that's
eye
where we're
knowledge that you're transferring at book value, when, well, no, if put it this way, if you transfer at book value in circumstances where you know it's worth more in the market, that's
Gower example.
which is the Gower example, then that is necessarily unratifiable.
Yes. And I believe, Mr. Norman, correct me if I'm wrong, I think the defence actually accepts.
Well, I can't remember exactly what they say, but they say something certainly in that direction.
And indeed, I mean, what Gower, interestingly, says the question is really to ask whether you would have transferred to a third party on the same terms.
And that's well, that's in the discussion of progress property, is it? I think.
Yes.
Yes. At any rate, the sorts of confusion that I'm sowing weren't necessarily got into in that much detail at trial.
No. But the point we're making in terms of the breach of fiduciary duty isn't dependent because we say, well, in terms of a breach of fiduciary duty, absent the tax evasion, that can be ratified. Provided it doesn't get to the point of blind eye knowledge when it's an unlawful distribution and cannot. Blind eye knowledge for these purposes is an additional submission because we say we get home on a lack of belief that the transfer price is the market value, given the terms of the representation that he knows is going to be made to HMRC. Is that what makes it tax evasion? Is that what makes it dishonest? Even if it doesn't extend to blind eye knowledge.
No, that's very helpful. Thank you very much.
Sorry, can I just be clear that I've understood that? Leave aside unlawful distribution. The example that my lord gave you at the outset of his questions, where there is knowledge on the part of the director of the subsidiary that it is being transferred at an undervalue. You said, I think, tell me if I'm wrong, that would be dishonesty in the Armitage and Nurse sense,
Yes.
which could be ratified,
Yes.
but it wouldn't of itself be dishonesty in the Ivy and Genting sense, which cannot be ratified. Have I understood
Correct.
that submission?
Correct.
And what makes that case different from the case which we're concerned with, you say, is that there was Ivy and Genting dishonesty in the form of an intention to deceive the revenue.
Correct.
It's that element of dishonesty in what would be a subsequent representation to the revenue, which moves it away from my lord's example, in which ratification would be possible.
That is so.
Thank you.
Thank you.
That is very helpful. Thank you very much.
Now, at the close of yesterday, I was about to go on to the judge's response to the pleadings points. Now, the pleading point, obviously, the pleadings point before the court, before the trial judge, was somewhat more restricted than our complaints that we're raising now, because there's a lot of judgment that was entirely new. But the one thing that was raised at the time was with respect to the belief. So Mr. Brown pleads that he believed the transfer prices were the market value. And when he says that, he refers to paragraph 14, and as we saw in paragraph 49.2, specifically says his belief was based on the independent valuation. But my learned friend gave us a list of issues suggesting, or on the basis that even if an independent valuation had not been obtained, it was still an open issue as to whether Mr. Brown believed that the transfer prices were the market value. And we were saying there's four facts. He pleaded he could not know what the market values were on his own. He pleaded he needed a proper valuation. And then he went on to say that he got one. And he pleaded that he believed the transfer prices were the market value based on the valuation. And obviously it was our position, if he hasn't got a valuation, he simply hasn't got any basis for the alleged belief. And on the admitted facts, he needs a basis for his belief. And the only one that he put forward, and he said that was the basis, was the obtaining an independent valuation. And therefore, it wasn't open to the court to conduct a roving inquiry into the universe of possibilities as to where the basis for the belief may have come from. And the judge deals with this point at paragraphs 59 to 65. This is page 104. And the judge there records in the final sentence, Mr. Brown's case, both in his pleadings and his evidence, is that he was aware of the need to obtain an up-to-date valuation of properties and that he did in fact do so. 60. Mr. Parker submits that it follows from this that if it is shown that Mr. Brown did not have an up-to-date valuation available to him, he must have been dishonest, as he has not put forward any other basis on which he could have had an honest belief that the transfer price was the market value of the properties. And then the judge records Mr. Norbury's submission, and the submission that if Mr. Brown genuinely believed that the transfer price was market value, fourth line, brackets, for whatever reason, the claimants cannot succeed. And in support of this, Mr. Norbury refers to the decision of the House of Lords in the Popplewell, and then there's a citation from what Lord Brandon said. And obviously you accept, if you say, Mr. Lord Brandon said it's open to the judge to pursue a third alternative, saying that the party on whom the burden of proof lies in relation to any averment made by him has failed to discharge that burden. But, and this is the critical point we say, the judge can't reject what's already been admitted. What's admitted is no longer in play. We don't have a burden of proof with respect to what's admitted. And then at 63, he then goes on to say, well, really, he says, this is not really a question as to whether the court is able to make particular findings of fact, but whether on the basis of the facts which the court is able to find, an inference of dishonesty is justified. Which again seems to be a reference to the burden of proof. And then he goes on, rejects my submission. Read as a whole, it's quite clear from the pleadings. The key question and issue is whether Mr. Brown acted honestly. Although I accept that CPR Rule 16.5 requires the defendant and their defence not only to deny an allegation but also to put forward their own version of events where appropriate, the failure to do so cannot relieve the claimant from having to prove their case. Mr. Brown had simply denied dishonesty and had not referred to any up-to-date valuation, it would still be up to the claimant to prove, based on the available evidence on the balance of probabilities, that Mr. Brown had been dishonest. Well, of course, that it was night follows day. He'd have been found to be honest because he admitted, successfully pleaded, I couldn't on my own believe the transfer prices were the market value. He expressly admitted he needed proper valuation. So when he doesn't get one, he's got no basis for believing the transfer prices are the market value. That's on his case. And 60.
Sorry, and so you say 65 is the it encapsulates the judge's mistake.
Yes, because the judge has this sort of vague point about inferring dishonesty, but this is about if you have established the facts. Once you've got facts based on what the parties have pleaded, then the question is, do those facts establish dishonest conduct in an Iving and Genting sense? The inference of dishonesty would be consistent with a situation of having to infer subjective dishonesty on the part of Mr. Brown. So there are these facts, that's dishonest conduct, objectively speaking, but I've listened to Mr. Brown, and I don't think he appreciated that would ordinarily be called dishonesty. In the Crown and Gauche sense, you could say you couldn't infer that Mr. Brown was aware he was being dishonest, but that's all gone under Iving and Genting. You look at the facts, you look at what he knew, and then you objectively determine the question of whether that's dishonest conduct. And because Mr. Brown was admitting he knew the terms of the representation that would be made to HMRC, admitting he didn't know what the market value was without some third-party input, admitting that third-party input needed to be a proper valuation, and claiming that he'd obtained one, the facts were in a fairly small compass. And what the judge rejects my submission at paragraph 60, which is predicated on there being no other basis for Mr. Brown having an honest belief. But what the judge does, he doesn't then proceed as if there'd been a general non-admission or a general denial, as Mr. Norbury invited him to do. What the judge does is provide some other basis. So the judge, in effect, accepts my submission, but then goes on to fill the lacuna that my submission is based upon. So the judge proceeds as if some other positive defence had been pleaded. Namely, yes, I didn't know without getting third-party input.
But I relied on Buckingham.
I didn't know, I don't say I needed to obtain a proper valuation. It was sufficient, which is what I did. I got a figure from Buckingham. So what happened is my learned friend had with his draft list of issues was saying, in effect, we don't want the judge to be confined by what's pleaded in the defence. And we said, no, the list of issues is supposed to be the issues raised in the pleadings, not just what you'd like the trial judge to do. And the trial judge never actually decided the point. But then, of course, in his judgment, came up with a whole bunch of new defences. So we would, if they had applied to amend to say that Mr. Brown is no longer saying that he needed a proper valuation, and Mr. Brown is no longer saying his belief was based upon proper valuations, and what he's going to say now is that he relied on Buckingham, and if that had been allowed, then at least we would have been in a position to address all the various matters that comes to. But they didn't. None of that happened. We then had the new defences that the judge came up with, which we hadn't even commented upon. But the judge proceeded as if there'd been a successful application to amend in front of him. And a new defence had therefore been raised. And we say that was, the judge thereby mistook the judicial function in coming up with defences that had not been put forward by Mr. Brown and conducting the trial, or considering the issues as if he was entitled just to conduct a general inquiry regardless of the parties' statements of case. So those, subject to anything further, those are my submissions on transfers of undervalue. Interim dividend.
Just before you move on, I'm not sure I've seen the list of issues.
My
which
learned
you've been
friend,
referring to.
yes, sorry, that was just attempt to spike his guns. My learned friend giving you all the various drafts of the list of issues, so I'm anticipating him relying on that.
His case is that the list of issues was broad enough to encompass this, is it? And you're saying
Yes.
that won't do because the list of issues ought to have been confined to the pleadings. Have I understood your point?
His draft list of issues tried to get the question of Mr. Brown's belief away from the obtaining of proper valuations.
Right.
And just say there's just a general issue as to whether Mr. Brown believed the transfer prices were the market value. That was his draft. And we said, no, that's not what your defence says.
And then was there ever an agreed list of issues then?
No.
Right. I understand. Thank you.
And they're all at divider 5 in the new divider 5 in the respondents are agreed bundle.
Thank you. Interim dividend. It's paragraphs 49 to 54 by skeleton argument. Now, this claim is appealed. The rejection of this claim is appealed on the basis that the judge was not justified in finding that Mr. Brown had acted honestly when authorising the dividend if Mr. Brown had blind eye knowledge with respect to the transfer of New Court being at undervalue. So if we fail on blind eye knowledge, we fail on this. And we say, on the basis of blind eye knowledge, which the court considered, that the judge's decision is illogical. So, on the 3rd of August 2005, Mr. Brown, with Miss Leonard, declared an interim dividend of over 5.5 million, signing minutes that declared that interim accounts were before the meeting. And we complained, the minutes, just for your note, are in our bundle at tab 46, page 178, and it's paragraph 7.7.
Sorry, tab
46,
46.
page 178, paragraph 717. Now, the appellants complained that, contrary to the minute, Mr. Brown had known that the financial statements before him did not record any of the tax liabilities of Carey Street, and therefore he knew those statements were not such as would permit a lawful dividend to be paid. And that just, we should look at the cross-examination on this. It's tab 9 of our additional bundle, page 48. On page 48, internal page 31, beginning at line 10. And if you read line 10 down to line 5 on page 32. Brown's obviously accepting that to be in a position to make a reasonable judgment from the interim accounts, it has to have all assets and it has to have all liabilities. And it was clear, as the judge found, that the interim accounts didn't have any tax liabilities in them. And we'll see how the judge deals with that in a moment. At the same time, on the assumption of blind eye knowledge on the part of Mr. Brown, that the 65 million transfer price was below the market value, one also factors in the fact that by the 3rd of August, Mr. Brown knew that the Collier's valuation had valued the property at 72 million. That's the valuation conducted for Credit Suisse. So obviously, Mr. Brown would be aware, on the basis of blind eye knowledge, that the undervalue could be substantial. And there could therefore be a substantial tax liability on the basis of the true value of the property. Now, the defence to this, if we can look at the core bundle at page 225, paragraph 50. Tabby 225. Though at the date of this amended defence, the defendant has not been able to locate them, the irrelevant interim accounts existed and were produced at the board meeting. Mr. Brown honestly believes such interim accounts.
Sorry, I'm looking at the wrong place, but
225, tab 11, page 225 of the core bundle.
and which? Oh, I see. Yes.
Paragraph 50, last sentence.
Yes.
He avers that he believes they were properly prepared. We've seen the cross-examination where he accepts that they should have had liabilities. Should have had all liabilities in there, and the judge finds they didn't have any tax liabilities in there. And then subparagraph 3, second sentence, is admitted and avert that Mr. Brown knew that Carey Street needed to have sufficient distributable profits to make the proposed dividend. He honestly believed to have such profits, as demonstrated by the interim accounts referred to above. So there is no defence based on anything other than the interim accounts having been properly prepared. Now the judgment addresses this. If we begin at paragraph 157, so the judge, 157 says Mr. Brown would have had a balance sheet. Paragraph 161, the judge finds that that balance sheet didn't contain any provisions for tax payable on the sale of vehicle. Paragraph 167 to 168 deals with the position on the this is addressing Mr. Brown not having blind eye knowledge. This is the accounts don't have the much smaller tax liability based on the figure of £65 million. Paragraph 167, 168. The judge says, well, that deficiency in the accounts is negated by the share subscription agreement. So to paraphrase, it's an innocent shortcut because the tax liability is picked up by the share subscription agreement. Last sentence, 168. Mr. Brown was clear in his evidence that given the existence of the share subscription agreement, the position was in his mind neutral. But and then we go on to see how the judge deals with the position on the basis of Mr. Brown having blind eye knowledge. 171, page 129. I should also note, the claimants make the point that if Mr. Brown knew that the transfer of New Court was undervalued, there would be an additional corporation tax liable on the increased gain. Of course, correct. He says, but the comments made above apply in exactly the same way. Mr. Brown would still not appreciate the omission of any provision for tax from his balance sheet. There's a problem, given his expectation that the liability would be met through the mechanism of the share subscription agreement. But we say that's where that's where the logic of his position breaks down. Because the comments with respect to the known tax liability with respect to the 65 million don't apply in the same way to the additional liability that Mr. Brown is seeking to evade. Mr. Brown would not expect that the liability would be met through the mechanism of the share subscription agreement. His expectation was that that liability would not be met at all because he's endeavouring to evade it. So it's completely different. You have the 150,000 on the note, the figure of 65 million. Everybody knows about that. When HMRC come calling, if the company can't pay, the share subscription agreement's there. It's very different for the additional sums based on the amount of the undervalue, because he's not intending that the share subscription agreement should meet that. He's intending that that tax never be levied.
Okay. Can we leave dishonesty on one side for a moment? In terms of the share subscription agreement, have we got that? Do we know what it said?
We haven't got it, no, but it's equity trust agreeing to purchase shares in New Court up to the amount of any liability that New Court has. And as the judge records, that's not something that would actually appear in the accounts.
So that's the liability of New Court.
Yes. So if HMRC had challenged the statement that the market value was 65 million and had come calling, the share subscription agreement would meet that liability.
They come calling on CSIL, didn't they? Who were the company that had made
Sorry,
the game?
I'm sorry, I think it's a new call. It's Carey Street, yeah. They come calling on Carey Street.
So
Sorry, it's to
the
purchase
agreement
shares
to
in
buy
Carey
shares
Street.
is in Carey
I'm
Street.
sorry,
Yes,
sorry.
I'm with you.
But the whole purpose of what's happening is that HMRC not come calling because the tax is evaded through representing that the market value is 65 million when he has blind eye knowledge that it isn't.
So just breaking it down, you say the known liability is different from the prospective liability, but the share subscription agreement would cover both, would it? Yes, I see. Leave on one side for a moment the potential extra liability. In terms of the known liability, the accounts were definitely defective.
Yes.
So then the only question would be dishonesty.
Yes. The judge's approach is he sort of short circuits that analysis and just said, he says Mr. Brown thought the accounts weren't defective because of the share subscription agreement. And we said, well, that's not right. The accounts are clearly defective, but you negate dishonesty because of the existence of the share subscription agreement.
So you do challenge that in relation to the
We're not-
known. In relation to the
We're
known.
not challenging
No.
the
In relation
judge's
to the known,
finding.
you say that's a legitimate finding of
Yes.
an absence of dishonesty, notwithstanding that.
Well, we
the
obviously
accounts were
at trial we
actually
said
defective.
signing. Sorry, I'm talking about. I must forgive. We said at trial signing a minute that said you were relying on interim accounts that you knew was defective was dishonest. But we're not pursuing that argument before this court.
Paragraph 168 you're not challenging. It's the
It's the
it's
171.
translation of the same philosophy into the
Thank you, yes.
the greater amount as a result of a known undervalue. Yes.
And
But the share subscription agreement would have the same effect in the known undervalue scenario.
it would have the same effect. If the evasion was unsuccessful, it would have the same effect. But obviously,
And
the
if
intent.
it were successful, then there wouldn't be a tax liability, so that equally there wouldn't be any.
But my lord, we say.
In Mr. Brown's philosophy,
Yes,
any shortfall in the management accounts.
yes. So this, sorry.
Sorry, go on.
I was just saying, but this is why the dishonesty is critical to this, because one has to, for the purpose of considering question of honesty, dishonesty, consider the position as it ought to have been if the director had acted honestly.
Well, so assume that, as I think the scenario we're in is Mr. Brown knows that this is an undervalue. To use figures, let's say he knows at this stage that the true value would be 72 million.
Yes.
Because he's had that. He therefore knows that there's been an under-declaration to the HMRC of 7 million or 7.5 million if you take the extra 500,000. No, 7 million. There are two possibilities. One is that the revenue don't challenge the 65 million figure, in which case there are no additional tax liabilities which need to be taken into account. The other is they do challenge the figure, in which case the share subscription agreement picks them up. And in either event, in his mind, in which the share subscription agreement can do the work, the position is the same, isn't it?
Well, this is why I say one has to look at the position on the assumption of a director being honest. The balance sheet should recall all liabilities. In my submission, that means you record all liabilities that the company actually has and not leave off liabilities that the company is able to, may be able to evade dishonestly.
But if a director could be mistaken but honest about the defect in the 500,000 not being on the balance sheet, why could they not be mistaken but honest about the 7 million not being on the balance sheet, in my example?
Because they know that the property is actually worth more than 65 million.
They may do, but they also think
And they,
that that'll be taken up by the share subscription agreement. So far as the dividend is concerned, which is what we're focusing on, does the judge's logic not apply equally?
well, the judge's reasoning is clearly flawed. There has been no respondent notice saying he should have found on the basis that there's no actual liability that needed to be recorded in the balance sheet on the basis that your lordship has put forward. I'm taking.
It's my fault. I'm not being. I'm not. I think putting to you anything different from what the judge was saying about the logic applying, or at least I'm.
Well, the judge is talking in terms of an expectation that the share subscription agreement will meet this liability, and they don't have that expectation because they're expecting that there won't be a liability, but that expectation of it not being a liability is based on dishonesty, which therefore is not a legitimate expectation, and there is therefore a substantial and material difference in the logic of the situation, as opposed to the judge simply saying, well, there's no difference between this situation and the situation of there being no such knowledge of an undervalue.
Just to understand the context, am I right in guessing that this would all have worked if HMRC had assessed to tax before CSI went into liquidation?
Yes.
And the problem arose because it went into liquidation, and so there was no question of a share subscription anymore.
Well, I think that might not be wholly right. The position, and again, this is none of this gone into, but the position is that after a certain time, before it went into liquidation, if HMRC had come calling, then yes, the share subscription agreement. If HMRC don't challenge the representation within a certain period, the only basis in which they can challenge it is on the basis of fraud.
So you need a discovery assessment.
So you need,
A discovery assessment.
yes, they need to discover what's happened and then say, well, in light of that, even though we would ordinarily be out of time to charge you tax on the true value, we're not.
Yeah. At any rate, so suppose they arrived. I mean, I assume they did assess in the end on this transaction, or did they not?
Well, I think they have, yes. But
In which case, if they had assessed immediately post the liquidation on the same basis that they ultimately assessed, I'm guessing at the facts a bit, the share subscription agreement presumably still wouldn't have worked, because at that point it would have required Equity Trust to subscribe for shares in an insolvent company, and I don't think that can be done, can it? I mean, a company in liquidation.
you live and learn.
I don't know.
that's a new
I
one.
mean, otherwise, why isn't Equity Trust paying up?
Yes. Yes, my Leonard Junior reminds me that because this was a Jersey trust, then obviously it is dependent on the solvency of the underlying assets of which Equity Trust is the trustee. So when the as happened, all the companies went bust at the same time.
Oh, I see. So there wouldn't have been any money there to pay up anyway. Yes, I see.
The judge says, well, at the time, there's a share subscription agreement, and Mr. Brown expected any liability picked up by the share subscription agreement. Subsequent thereto, in fact, the trust hit difficulties with about 2006, 2007, and therefore the share subscription agreement was of no use.
Yes, I see.
But obviously, for present purposes, we don't pray in aid the fact of an additional risk or anything of that sort. We pray in aid the underlying dishonesty in not having regard to a liability that you should have had regard to when paying the dividend. And we say the share subscription agreement is no answer to that complaint, because your intention is that the share subscription agreement should not pick up this liability, because you'll never be charged for it.
Yes, I see.
And we've highlighted that the acceptance in Malone Friends closing at 180 of the dishonesty involved, which is paragraph 180, it's bundle 3, paragraph 65, because Malone Friends.
Sorry.
In terms of looking at that.
No, I didn't catch what.
Sorry.
There was a reference to 180. Is that
Paragraph 180.
in the closing submissions?
Yes, and that's core bundle. Sorry, that's respondents bundle, tab 3, page 65.
This submission depend upon a further submission that the judge ought to have found not only that Mr. Brown knew or had blind eye knowledge that the transfer was at an undervalue, that he expected that the revenue would not challenge that.
My submission,
I think that was a necessary part of the way you were putting the difference between his state of mind in relation to the 500,000 and any shortfall from an undervalue.
in my submission, not. Whether or not the liability the liabilities should be drawn up on the basis of honesty, and honesty would dictate that the recognition of the fact that if challenged, there will then be a substantial liability because the 65 million was at an undervalue. Then when one come on to the share subscription agreement, that can't be prayed in aid as negating the dishonesty in paying a dividend on the basis of defective interim accounts that omit that liability, because you're intending that the extra tax liability not be paid by the share subscription agreement. Now, you may think, well, I don't know what the chances are of getting away with this, but you're doing this because you want to get away with it. And that's what makes it the expectation, in inverted commas, of a totally different sort to the expectation you have with the small tax liability that you're accepting.
That's a slightly different point from the one I thought you were making. I thought you were making the rather simpler point that the difference between the 500,000 and any shortfall on a known transfer at an undervalue was that in the former case, the expectation was that the tax would be payable on it, and therefore the subscription agreement would pick it up, and that's what negated honesty. But in the latter example, the expectation was that there would never be a tax liability at all, and therefore the subscription agreement would not, as a matter of expectation, come into play. That, as I understand you, was the distinction you were drawing, and that's why I was putting to you that it depended on the expectation being that the revenue wouldn't challenge it.
I've used the word in both factual situations, but I said that there needs to be refinement in terms of expectation, referring to the probability of something happening. We say that the relevant concept is perhaps one of intention. With the smaller liability, the smaller known liability, it's the party's intention that it be picked up by the share subscription agreement. With the larger liability that ought to have been in the accounts, the intention is that it not be picked up by the share subscription agreement. So this is a liability that, again, is based on Mr. Brown knows that 65 million is not the market value.
The expectation may have been it would be picked up by the share subscription agreement if the revenue challenged it.
Yes.
And I'm just not sure we've got any findings to say that was Mr. Brown's state of mind.
And I apologise for using the word expectation in both situations. But my submission is that the reason why there's a fundamental difference between the two situations is the intention that negates the dishonesty for the known liability is that the share subscription agreement meet that liability. There is no such intention when one deals with the additional liability on the true market value. So, of course, what should have happened, an honest director would have transferred the property at the true market value. The unknown liability that we've been talking about would have been a known liability that would have needed to go into the interim accounts. And if it hadn't gone into the interim accounts, at that point, the judge's reliance on the share subscription agreement as picking up that known liability would be sound. But the judge doesn't recognise the fundamental difference that on the actual facts, there was no intention that the share subscription agreement should cover that liability. Now, moving on, if I may, to the £766,000 left outstanding for the purchase price. This is Armitage and Nurse dishonesty, which can't be ratified because of insolvency. Now again, as the judgment recognises at paragraph 262, this is dependent on blind eye knowledge. And the reason it's dependent on blind eye knowledge is it's the blind eye knowledge that makes Mr. Brown aware that the transfer will render 245 Blackfriars insolvent. And because of the insolvency, Mr. Brown wasn't at liberty to do the holding company a favour. So just breaking that down perhaps, we said it's extraordinary to leave part of the purchase price outstanding without some form of security. There's no security, there's no protection, there's no indemnity, it's just left outstanding. And Mr. Brown was asked why he did that. His answer is in our additional documents. It's tab 9, page 50, and it's 115 line 9 to 116 line 7. And he says he did it as a favour to the holding company.
Sorry, just give me the reference again.
It's tab 9, it's
Yep.
page 50, internal page 115. Line 9 to page 116, line 7.
Yes.
And obviously, doing the holding company a favour would not be objectionable if 245 Blackfriars were solvent. But on the basis that Mr. Brown knew that the true genuine liabilities are on the basis of a market value of the property that was more than 78 million, he knew what was reckless as to whether the £269,000 surplus that appeared on the balance sheet, or the one derived from the balance sheet, would be wiped out by the true genuine liability. So the balance sheet for 245 Blackfriars is on our documents at tab 69, page 263. The balance sheets that Mr. Brown said he would have seen before signing certificates of solvency. Right-hand column, the property's in at 78.5, it's being transferred at 78. So one takes the £500,000 off the net asset figure of 769,142, which leaves net assets of 269,142. Given the knowledge that the transfer was at an undervalue, the genuine liabilities would have wiped out that 269 figure. And then the only further observation on that is in the judgment at paragraph 263, that's called tab 7, page 146. That's where the judge says, it seems unlikely that of any fraudulent breach of duty if Mr. Brown had no reason to suspect that the loan would not in due course be repaid. Expect that the loan would be repaid in due course when funds were needed broadly for the reason set out. But obviously, this is not Ivy and Genting dishonesty. This is Armitage and Nurse. He's consciously acted in the interests of the holding company, disregarding the interests of the creditors. And that's not cured by the fact that he says, well, I didn't intend that the creditors should suffer any harm.
Can we just think about that one moment? You say disregarding. Well, you didn't think there was a problem from creditors' point of view.
Well, the decision to leave the money outstanding has got to be taken in the interest of the creditors.
He's got to have regard to the interests of creditors. But on the facts, according to the judge, he didn't think there was a problem for creditors because the money would come in.
But the decision that's under review is not being taken in the interest of the creditors.
And then why should Armitage and Nurse govern this?
Sorry?
Why should Armitage and Nurse govern when we've now got Ivy?
Well, that would have been an interesting question. It's not one that's been raised. I mean, just to be clear, this particular liability, he hasn't had regard to the creditors in the sense that he hasn't obtained any, say there's no indemnity security, he hasn't done anything to look after the interests of the creditors. He may think it doesn't matter because the holding company will be good for the money, which in due course obviously it wasn't. But he's not actually doing anything. This isn't the situation that's picked up by the share subscription agreement or anything. There's no protection for the creditors. Now,
And that's what the judge relies on at 263.
sorry.
At 263, the judge is saying it's all okay actually because it would all be picked up in the share subscription agreement. It's his conclusion again.
But 263 is just saying he thinks it'll get paid. He thinks the outstanding 776 will get paid.
Yeah.
And no reason not to do that. But that's not the share subscription agreement. That's just these are profitable property holding companies,
And it will get paid.
and they'll get paid. So it doesn't matter. But we say no, because the decision that we're complaining about was solely taken in the interest of the shareholders. Now, I'll have to crack through management charges and interest. We need to see how this is put to understand, I think, and see how it's put and see how it's defended. It's tab 10, page 184.
This is of your bundle.
Call button, sorry.
A cover.
So the basic facts under interest payments, paragraph 24, they're not in dispute. There was an interest-free loan with the holding company, and then 2 years later, Mr. Sirra, Buckingham's Mr. Sirra, advisor to Equity Trust, suggested that interest should be charged to Carey Street on the previously interest-free loan from the inception of the loan, saying it should be assumed to have been a mistake, and he also suggested that there be a charge of £150,000 for a number of services that he then suggested, including with the end there, etc. Now, we contended sub 26 of paragraph 1 that despite the fact that, as was clear from the documents held by Equity Trust, the interest-free nature of the loan had not been the result of any mistake, and the judge found it was a deliberate decision for tax reasons, namely it avoided withholding tax, that they agreed. That Mr. Brown agreed to the retrospective payment of interest. And 1B, we pleaded, Mr. Brown did not check the circumstances under which the loan had been arranged, specifically as to whether there had been any mistake or whether there might have been a reason for the loan being interest-free. And as we say that those allegations, sorry, if you look over the page 1C, top of 186, in the premises, Mr. Brown knew that the retrospective interest charge was a device for generating a purported liability owed by Carey Street to Newcott Properties in order to reduce the tax payable by Carey Street. And then at 26.2, underneath that, Mr. Brown acted in bad faith, otherwise than what he honestly believed to be the interest of Carey Street, and dishonestly in order to minimise the tax that would be payable by Carey Street. And similar allegations are made with respect to the management charge. And it will be appreciated that both decisions with respect to the interest and the management charge involve agreeing to pay charges retrospectively. And that's the critical point. That's the real focus of the complaint is what on earth are they doing, agreeing to paying these charges retrospectively? So they're making a payment in respect to benefits received for, or received or arguably received, for which there's no legal obligation to pay. And so the questions raised were obviously, how could that be thought to be in the interest of Carey Street? And why was Mr. Brown agreeing to it, if not for the purpose of reducing the amount of tax payable? And therefore, if it's not to be a device to generate a purported liability in order to reduce tax, Mr. Brown would have had to have thought that Carey Street was simply recognising a pre-existing liability. And we see an attempt to present this as a recognition of a pre-existing liability when it clearly was not. Now, respondents' defence to that is tab 11, page 219. Paragraph 35. Paragraph 35, they say, denied the basis put forward by Mr. Sirr for charging interest on the relevant loan was erroneous. Well, it was. Or further alternative, the defendants are either knew it to be. And then 36.3, it is admitted that Mr. Brown agreed that Carey Street should pay the interest that Mr. Sirr indicated it should pay. He did so in the good faith belief that doing so was in the interest of Carey Street. He formed the belief independently in reliance upon the advice of Mr. Sirr. And then at 4B, page 220, it is denied as a matter of law that Mr. Brown was obliged to make any of the alleged inquiries. Given the lapse of time, Mr. Brown does not recall what, brackets, if any, inquiries he in fact made. So they're accepting he might not have made any inquiries. Paragraph 6, subparagraph 6, page 220. Again, Mr. Brown believed it was in the interest of Carey Street to pay the interest that Mr. Sirr indicated that it should pay. But there's an explanation as to why he thought it was in the interest of Carey Street beyond the simple fact of relying on Mr. Sirr. And there's no averment that Mr. Brown thought he was simply recognising an existing debt. I don't know if I put the way it's the same. Now moving on to the management charges, at page 220, tab 11, 220, paragraph 37. Mr. Brown agreed to pay the relevant management charges. In particular, the following services had been provided by New Court Properties Limited to Carey Street. And then there's various services there said. And that factually is a nonsense. New Court Properties didn't have any employees. It hadn't provided any services to anyone. And in fact, the services in question had actually been provided to whomever, and we shall see, by Buckingham. And we submit that the introduction of New Court Properties into this is obviously being introduced for tax reasons. The unnecessary charges would not therefore be lost to the shareholder because the money was being paid to New Court Properties rather than to Buckingham or anybody else for the purposes of reducing tax, as we see. And Buckingham were in fact paid for those services under a pre-existing management agreement with Equity Trust. Now, 37.2, this is page 221, pleading says, it's admitted Mr. Brown agreed that Carey Street should pay the management charge that Mr. Sirra advised it should pay. He did so in the good faith belief that doing so was in the interests of Carey Street. He formed that belief independently upon the reliance of Mr. Sirra. Again, no positive reasons put forward other than reliance on Mr. Sirra. 37.4a, again, might not have made any inquiries. 37.5b, 37, paragraph 5, again, the averment, he thought it was in the interests of Carey Street to pay the management charge that Mr. Sirra advised it should pay. So, on the defences, no averment. Mr. Brown thought he was recognising an existing liability. No reasons given for his thinking that this is a debt that needed to be paid. There was an assertion that Mr. Brown had acted independently, but that assertion was rejected by the judge. You can see that at tab 7, page 132. Paragraph 191. Second sentence. It is apparent from the documentary evidence that Mr. Brown and the team at Equity Trust relied on the advice from Mr. Sirra and acted accordingly.
I'm afraid I didn't catch the paragraph number.
191, my lord,
Yep.
page 132. And then over the page, paragraph 191, over page, paragraph 192, page 133, he says, I'm not persuaded that Mr. Brown can be said to have been reckless as to whether he was acting in the best interest of Carey Street. I accept that little, if any, independent thought was given by Mr. Brown to the amount of the fees. However, looking at the range overall, taking account of the thought given to the justification for the services in the first place, it is my view implicit that Mr. Brown considered the fee to be appropriate. The evidence certainly doesn't suggest me that Mr. Brown simply did not care whether the fee was justified. Now, what we say, and then the fourth point from the defence is this: Mr. Brown simply relied solely on Mr. Sirra, thinking it was the best interest of Carey Street to do as he suggested. And the judge found that Mr. Brown did rely solely on the advice of Mr. Sirra, no independent thought. Now, what we say is, if Mr. Brown had thought that Mr. Sirra was advising in the best interests of Carey Street, and that Mr. Sirra was therefore simply identifying pre-existing liabilities, then, as the judge held, Mr. Brown might be thought to be nothing more than negligent. But, and this is critical, the judge held that Mr. Brown knew that Mr. Sirra's purpose in suggesting these charges was to reduce the profits of Carey Street and enable money to be passed to the shareholder out of the jurisdiction free of tax. So if you look at the judgment, tab 7, tab 7, page 131, paragraph 182. There says, whilst I accept that Mr. Brown is likely to have been aware that Mr. Sirra's purpose in raising the issue of a management fee was to reduce the taxable profits of Carey Street, It then says, I reject the allegation that Mr. Brown didn't consider the management fee to be justified. And similarly, at paragraph 202 on page 134, I have little doubt that, given the timing of the proposals made by Mr. Sirra, Mr. Brown would have been well aware that the main purpose of charging interest on the loan respectively was to reduce the taxable profits of Carey Street. And as the judge has just said, no independent thought given to this by Mr. Brown, the judge is finding that Mr. Brown never tested the advice that Mr. Sirra was giving for the purpose of reducing the profits of Carey Street against a different purpose, namely to see what was in the interest of Carey Street. Because obviously it's not in the interest of Carey Street to have its profits reduced, which the judge says Mr. Brown knew was the purpose for which Mr. Sirra was advising. We say, therefore, that the allegation that Mr. Brown acted dishonestly in order to minimise tax was made out, and no judge could reasonably thought otherwise. Now, the difficulty in terms of my timing is that the judge went on to consider whether nonetheless Mr. Brown's team could have concluded from their investigation that these charges were justified. In terms of the best interest of Carey Street, as said, they could only be justified if there were pre-existing liabilities. And at one point, the judge appears to appreciate that. In paragraph 203, he says, of course, if the interest-free nature of the loan had been the result of a mistake, then there'd be rectification and the liability would run from the inception of the loan. And to that end, we see, if we look at the judgment again, we see the judge relying on the questioning of the team. Paragraph 104, page 114. I think we looked at this yesterday, is the judge's finding that the facts known to Mr. Brown's team are likely to be known to Mr. Brown as well. Then, if we please go to page 131. Paragraph 184. This is dealing with the management charges. As far as the services themselves are concerned, the documentary evidence shows Mr. Brown's team at Equity Trust did question Mr. Sirra quite carefully about the justification for the management charge. And those investigations appear from the documents. We've got what we believe are all the documents evidencing those investigations in our appellant's bundle. But for present purposes, I think I'm going to go to a very limited number. But what they show is that the notion of a mistake is floated by Mr. Sirra to Equity Trust. It's not mentioned thereafter. No suggestion that this would justify paying interest retrospectively. And they also show that the team were well aware that the services were being decided upon for the purpose of raising the management charge on an ad hoc basis, and the services would change, and the figure of 150,000 was plucked out of the air before they decided what services it was in respect of, and the period for which it was charged changed, and fundamentally that the team were well aware that those services had been provided by Buckingham under an existing management agreement with Equity Trust, for which they were being paid £130,000 a year. So if we could just begin, it's tab 23 in our additional documents bundle, page 142. Yes. This is the pre-existing management agreement.
So sorry, could you give me that reference again?
It's page 142, which is at tab 23.
Thank you.
We see it's Equity Trust and it's Buckingham Services. Clause 4 sets out the management functions, efficient management operation of the properties. And then if we go to page 146, we'll see that the agreement 11.1 runs from the 1st of January 2003 for 2 years, and on 11.2 they're paid £130,000 for the first year, and then at page 147 we see the schedule of companies to which this applies, and we see that Carey Street in manuscript has been added in the right hand column. Then if we please go to tab 25, this is the origin of these charges. It's Mr. Sirrah, top of the page, emailing David Haynes at Equity Trust with respect to the accounts. So Mr. Haynes has chased Sirrah on the basis it's getting so late in the day that they really must file the draft accounts. And the response is, you see at the top of the page, I attach a few issues arising from a review of the tax issues. And then those issues appear at page 152. Hence needing clarification, the loan from Newcourt Properties effectively a low-ranking junior loan should accrue interest at 12%. The fact the loan agreement says it is interest-free should assumed to be an error. That's the only place you see any reference to any error. And then secondly, we should accrue management charges from Newcourt to Carey Street of £150,000 for provision of investment, financial advice, etc., including, as we say at the end, for the provision of directors and officers. And then if we please go to next page, next item, tab 7, 153. So the interest-free loan, which could be seen from the documents in the file, had been deliberately interest-free for tax reasons, is discussed. There's a rationale as to why 12% should be charged. No discussion as to why it should be retrospective. No mention of any error. Then the management charges in the second paragraph. Management charges from Newcourt to Carey Street of £150,000 were discussed. Buckingham has obtained planning cards, etc. And potential tenants on behalf of Newcourt Properties in accordance with the management agreement in place with the Ironsar Trust. Buckingham Services will shortly be invoicing Newcourt Properties for the works undertaking. So there's a recognition that the services they're talking about are being provided under the pre-existing agreement with Equity Trust that we just looked at. No consideration anywhere as to why it would be in the interest of Carey Street for interest to be charged retrospectively, or why it would be in Carey Street's interest to pay Newcourt for services that had been rendered by Buckingham to the trustee without any obligation on Carey Street to have paid for them. And then if we go to tab 29, page 155, Olswangs, when informed of the fact that interest is going to be charged on a previously interest-free loan, specifically say, third sentence, presumably this increase will only apply from the date of the change as distinct from being retrospective. Please confirm. It then expresses doubts as to whether the interest charge would be accepted by HMRC. But you do not find anywhere anybody going back and saying, well, it's going to be retrospective because there was an error. Then, if we go to tab 30, please. It's another file note of Rachel A. Cook's conversing with Harry Sirrah on this, and this is where they're finalising the terms of the agreement. It's about the middle of the page, clause 5, the period 3 years, the fee for the first year should be £150,000. And the services, as we see, have been reduced from those that were originally suggested. And in fact, when the agreement's signed, the £150,000 is payable for a period of 7 months. And then one sees 2 paragraphs down, this agreement shall be effective from the 27th of May 2002, retrospective. Although this may seem to be retrospective, it is merely formalising the existing arrangement. Is it possible to build this into the agreement. And then the agreement is at, sorry, what tab 33, sorry, this is the minutes approving the agreement. So there's a list of services, so the notion of providing directors, officers and the like, that's been dropped. It's focusing solely on the property services that's been recognised and been provided in the existing management agreement. And it says that the chairman, Mr. Brown, advised that in order to formalise the arrangement between the company and its parent, Newcourt Properties, a property management agreement has been drafted. And it was resolved that the property management agreement to formalise the arrangement between Newcourt and the company be approved. So the investigation that's conducted recognises that this should only be paid on the basis that it's a pre-existing liability, builds that into the documentation on the basis it's said to be recognising the existing arrangements, but at the same time the investigation has quite clearly appreciated that these services had been provided under a pre-existing management agreement between Buckingham and Equity Trust. So that's the knowledge that by paragraph 104, the judge imputes to Mr. Brown. And that's the only knowledge Mr. Brown has, other than, as the judge finds, without thought, he's acting on the advice of a man who he knows, the purpose of which he knows, is to try and reduce the profits of Carey Street, because he's an advisor to Equity Trust and not to Carey Street. Now, yes, everything else I think is probably along the same lines. We do point out, again, in terms of there being no mention of an error, the BDO letter referred to in the judgment of paragraph 48. Again, no response to BDO that says the reason it's retrospective is because there was an error. And you recall that Mr. Sirra didn't say there was an error. Mr. Sirra said to Equity Trust in a note that's for the purposes of reducing the profits of Carey Street, it should be assumed to be an error. They've got the documents that show that it wasn't, and nobody in the team thereafter refers to that. So it's not nobody. It can't be said that anybody genuinely thought there was an error. And I reiterate, he's acting on the advice of somebody who he knows is advising for the purpose of reducing Carey Street's profits. Now, in the judgment, I haven't really got time to go through it, but in the judgment, you find no recognition of the consequences of the judge finding that there was no independent thought and that Mr. Brown knew that Mr. Sirra was advising for the purpose of reducing the profits of Carey Street. You find reference to allegedly careful questioning. Again, no reference to the pretense of the management charges being the formalising of a pre-existing arrangement. No reference to how the £150,000 figure was arrived at before they even knew the services for which the £150,000 was to be charged, or before they'd even decided for what period it was to be charged. So what the investigation actually did was confirm that these were not pre-existing liabilities and were being levied for the purpose of reducing profits, increasing the tax. And therefore, every time the judge says about the evidence, I'm not convinced from the evidence, but there's just no recognition of what the evidence actually showed. Now, I need to move on.
It's very irritating for you that I keep interfering with that. But just on the management charges, there are various strands to your argument. I don't want to pick all of them up. There's the services having been provided, not by Newcourt, but by Buckingham. Your points you make about the amount and so on. But you introduced the point to say that the main point was the retrospectivity of it, in that there was no pre-existing liability
Yes.
on CSI to
Yes.
pay these. But as I understand it, there were property services which had been provided to CSI before this arrangement was put in place, which it would have needed to have had provided to it in relation to management of the property of which it was owner. And would it not have been under a legal obligation to pay for such services by way of quantum merit, even if there weren't a contract in place?
Well, my lord, they hadn't been provided to Carey Street. They may be
They had
services
been,
for
I'm so
which-
sorry to interrupt, but they had been, hadn't they? Because Carey Street was the owner of the property, and these were services of a kind which the owner of the property needed to have performed.
They're services from which Carey Street may have benefited, and that's reflected in the existing management agreement, that Carey Street being one of the companies that's listed for whom the management services are to be provided. But there's a pre-existing arrangement whereby Equity Trust is going to pay Buckingham for providing those services. And Buckingham couldn't raise a quantum merit for services that they're being paid for by Equity Trust. New Court couldn't raise any quantum merit because New Court hadn't done anything.
All right, thank you.
Now again, the judge has a paragraph discussing about the possible contractual interrelationship that might have existed that nobody's gone into. But when one looks at the documentary evidence of what was going on, there's simply a recognition that these are services that have been provided by Buckingham pursuant to a management agreement with Equity Trust, and there's going to be a pretense that in fact they would be provided under a pre-existing arrangement to be paid for by Carey Street. If you just
Right, thank you.
I'm having to resist the urge to gabble, but I'll try and bring a degree of clarity to my submissions as I move on to the liability of Equity Trust, which you've seen is put on the basis of vicarious liability or de facto shadow or de facto director. Addressing vicarious liability first. We make the obvious but important preliminary point that the liability of Equity Trust only arises if the claim against Mr. Brown is made out. But on that basis, Mr. Brown's actions were for the benefit of his employer as the trustee of Ironside Trust. They were consistent with Equity Trust's commercial objective of saving its clients' tax. And we say the judge's sole reason for rejecting the vicarious liability claim is because the wrong in question was committed by Mr. Brown as a director of another company. And the judge thought he was prevented by legal principle from finding that an employer was liable for a breach of fiduciary duty by his employee as a director of another company, relying on the Privy Council case of Kuwait Asia. That was the judge's only reason for rejecting the vicarious liability claims, and there's been no notice from respondents under CPR 52.13. Now, the respondents take issue with that description of the decision, but we say it is clear that the judge is deciding the point on the basis there's an absolute bar on finding an employer liable for the conduct of an employee as a director of another company. Now, the judge held it was part of Mr. Brown's job to act as a director of other companies. Paragraph 293 to 294, page 152. And of course, at no point was it suggested, nor could it be suggested, that Mr. Brown was on a frolic of his own. So one might have thought applying all the principles of vicarious liability, that vicarious liability would be imposed. But the judge rejected the claim, and it is clear from the judgment, it's clear from the judgment, first of all, this is paragraph 269, that the claim was being defended by equity trust on the basis that, as a matter of principle, an employer cannot be vicariously liable for the act of an employee as a director of another company, even if it is part of the employee's job to act as a director of other companies. And so the judge started with the consideration of the two-stage test for vicarious liability. That was at paragraph 274. But then, when one considers paragraphs 287, 294, 295, and 296, we say it is clear that the judge was treating himself as prevented from imposing vicarious liability by an absolute bar which he derived from Kuwait Asia. Now, turning, if I may, then to the question of whether the judge was right to view Kuwait Asia as determinative of this issue, it is submitted that Kuwait Asia should not be followed for three reasons. The first is, whatever rule Kuwait and Asia might be thought to be authority for, the rule should not prevent liability being imposed if to do so would otherwise accord with the modern law of vicarious liability. The decision predates the modern law of vicarious liability, and to the extent that it is in conflict with the modern law of vicarious liability, it should not be followed. Secondly, this court has held that an employer can be vicariously liable for a breach by its employee of the fiduciary duty of loyalty that it owed to another. As a matter of principle, we say there is no reason why that should not also be the case where the fiduciary duty is owed as a director. And thirdly, the reasoning in Kuwait Asia itself is not compelling and is not applicable to the facts of this case. Now, taking those 3 points, the first one is we say that this is Kuwait Asia not being in accord with the modern law of vicarious liability. Now, we say it's important to recognise that this is not a case where it can be said that the duties of a director were such that they rendered the employment contract an irrelevance. Now, the defence makes this point. It is tab 11, page 207. Paragraph 10, subparagraph 1.
I'm sorry, that was page.
Page 207.
Thank you.
Paragraph 10, there's denial as a matter of law that equity trust is vicariously liable for acts and omissions in his capacity as a director of the claimants. So that's the principle that the judge, the alleged principle the judge applied. So paragraph 1, although Mr. Brown was at all 2 times an employee of equity trust, he owed independent and non-delegable duties to the claimant in each of them, including the duty to exercise independent judgment. Such duties were separate and distinct from the duties Mr. Brown owed to equity trust Kuwait employer, and took precedence over the latter duties. And we said, in response, that is obviously the paradigm situation, but it didn't apply in the facts of this case. Mr. Brown's duties should have taken precedence, he should have exercised independent judgment, and he should have discharged his duties to the claimant companies, but he did not. Therefore, we say, when one looks at the conclusion that the defendants seek to draw in paragraph sub 10, subparagraph 3, namely that equity trust had no control over Mr. Brown and his actions as director of the claimants, there's no logical basis for that. And furthermore, it elevates control, the question of control, to a paramountcy in vicarious liability that it actually doesn't have. And moreover, as we will see, here, of course, the notion of independence is risible in circumstances where clearly there was considerable control or influence over the employee exercised by equity trust over its employee as a director of the company. The employer, on the facts of this case, would ask its employee to sign documents as director that the employer had prepared. And that's, we see in the judgment at 309.310, and we'll be coming on to that in the context of shadow directorship. Now, the modern law of vicarious liability was recently reviewed by the Supreme Court in the BXB case that we have in the authorities at bundle 3 of the authorities, tab 18. We've highlighted all the places where there's reference to the modern law of vicarious liability, which is said to have arisen at the beginning of this century. But we highlighted paragraph 58 in particular in our skeleton argument on page 756 of the bundle, page 971 of the decision. And if you could kindly read paragraph 58, little 2. It's really the second half of that paragraph.
Okay.
Now, obviously here, stage 1 is satisfied because of the employment contract. So applying the two-stage test, you wouldn't get on to the list of factors that we find at this subparagraph. But we say that what it shows is that these factors are relevant and are highlighted because there's nothing from Mr. Brown's position as a director that negates these factors that are said to be relevant to the imposition of vicarious liability. So even if you say, well, let's disregard the fact that he's got a contract of employment, these factors apply to what Mr. Brown is doing for the benefit of his employer. And the conduct in question was for the benefit of the employer, both as trustee of Ironside Trust and more generally as a service provider offering tax saving schemes to its clients. Now, the judge appeared to take issue with that, with the relevance or even acknowledging that that was a benefit to the employer. That's at paragraphs 285 to 286. Called by the tab 7, page 150. But it is clearly in the interest of Equity Trust to be seen to be performing its role as trustee of a family trust involving tax saving structures, to be seen to be performing its role successfully in avoiding taxes, avoiding in inverted commas, and is charging for those services. Now, when considering this point of benefit to the employer as a reason for departing, so the judge was considering this point of benefit to the employer as a reason we put forward for departing from any prohibition that the judge considered was derived from Kuwait Asia. And we say, if one puts to one side the question for a minute as to whether there was an absolute prohibition in Kuwait Asia, we say it cannot be in dispute that benefit to the employer is undoubtedly a relevant factor in favour of the imposition of vicarious liability. And then applying the second stage of the test, which is again staying with BXB, the close connection test, whether the wrongful conduct was so closely connected with acts that the tortfeasor was authorised to do that it can be fairly improperly regarded as done by the tortfeasor while acting in the course of his employment or quasi-employment. Here, again, as we shall see, Mr. Brown was implementing the decisions that have been taken by Equity Trust. So the second stage of the inquiry is obviously satisfied. And then, staying with BXB, if we go to page 972, page 757 of the bundle 3, little 4, the relevance of policy. Little 4, as made clear by Lady Hale and Barclays Bank, drawing on what Lord Hobhouse said in Lister, the tests invoke legal principles that in the vast majority of cases can be applied without considering the underlying policy justification for vicarious liability. Tests are a product of the policy behind vicarious liability, and applying the test, there's no need to turn back continually to examine the underlying policy. This is not to deny that in difficult cases it can be a useful final check on the justice of the outcome to stand back and consider whether that outcome is consistent with the underlying policy. And then at the end, the last sentence, at root, the core idea appears to be that the employer or quasi-employer who is taking the benefit of the activities carried on by a person integrated into its organisation should bear the cost, or as one might say, should bear the risk of the wrong committed by that person in the course of those activities. And therefore, we say that the policy would dictate the imposition of vicarious liability on the facts of this case. Now,
Because the activities that Mr. Brown is employed to carry out are not merely to be appointed as a director, but to carry out his duties as a director. And is that the simple point?
well, he's been appointed not for the purposes of ploughing his own furrow as an independent director, considering the interests of Carey Street. He's being appointed as a director of a company within an overall tax structure that is required to perform that role. I mean, the tax, when one's dealing with this sort of tax structure, it'd be very odd if they actually expected their employees to act independently of their employment relationship. They're not expecting the directors to turn around and say, why on earth would Carey Street want to sell this property? The market's going up, we're going to hang on to it. No, because that destroys the whole purpose of the hive out of the jurisdiction. So the benefit we see to the employer here from the person who remains part of their organisation is in no way unexpected, which is why it can't be said to be Mr. Brown being on a frolic of his own. Now, the fundamental point is that we say there's a world of difference between a situation where the employment relationship is but a background fact, explaining only how the person came to be a director, and the situation where the director's relationship with his employer continues to be relevant. Here on the facts, it continued to be relevant. Indeed, the breach of duty arose from carrying out the wishes of the employer from which the employer benefited. Therefore, whatever the conclusion might be with respect to a director's negligent but honest discharge of his duties with no benefit to the employer, the facts of Kuwait Asia, the assumed facts of Kuwait Asia, Mr. Brown's breach was clearly one for which, under the modern law, the vicarious liability should have been imposed. Second point is, we point out that this court has held that an employer can be vicariously liable for a breach by its employee the fiduciary duty of loyalty that it owed to another. And we say there's no reason why it should be different just because the fiduciary duty is owed by a director. And the judge recognised that. If we look at his judgment in tab 7, page 148,
Sorry, which paragraph?
that's paragraph 275. He recognises there's no doubt that liability can be imposed for breach of fiduciary duties. Now, as the judge recognises at paragraph 278, when dealing with Kuwait Asia, there may be said to be, considering what the difference might be said to be, they said to be a sensitivity about making inroads into the principle of limited liability. But we say that is a misconceived notion, because the liability in question is not being imposed because of the employer's position as shareholder. It's being imposed because of the employment relationship. Now, this is a point that was made by Mr. Justice Thomas of the New Zealand Court of Appeal in a chapter in Corporate Governance and the Duties of Company Directors, which we have in tab 26 of our authorities, and we've marked the relevant passages, and we would ask the court to read those passages if they're able to find time.
Can I just make sure that I've identified what you're referring to?
It should be the fourth bundle of the authorities, tab 26.
And it's marked up from 883 onwards, is it?
Mullen, yes. As Justice Thomas there says, the liability in question is being imposed not on the shareholder because he's a shareholder, it's being imposed because he's an employer. And the final observation before turning to the facts of Liquidation is we say such a concern about making inroads into the principle of limited liability might be justified where the fact of the wrongdoer being an employee is purely incidental, and following his appointment as a director, the employee has ceased to be part of the employer's organisation and the employer is not taking the benefit of his activities, such that the policy of vicarious liability is not engaged. But that is not the situation here. Now, Mr. Justice Thomas described Kuwait Asia as, quote, highly unsatisfactory. And we have that decision in the first bundle of authorities at tab 2. Now, the facts of the case, two people, one called August and House, were appointed by a bank, employees of the bank, appointed to act as directors of a money broker that went into insolvent liquidation. The trustee for the depositors sued the bank as vicariously liable for the negligence of August and House as their employees with respect to certificates of compliance that the money broker had sent on behalf of the directors to the trustee for the depositors. And the relevant reasoning on vicarious liability is at page 221 of the judgment. So it's tab 2. Page 221 of the judgment.
39 of the bundle.
So yes, in terms of yes, page 39 of the bundle. And the reasoning begins the third line at the top of the page.
This is who's speaking.
Lord Lowry, I think. Yes. Now, we say, as we'll see, Lord Lowry begins not by considering vicarious liability, which doesn't require any breach of any duty by the employer. He begins by considering whether the bank owed a duty to creditors, and says, fourth line, in the absence of fraud or bad faith, a shareholder or other person who controls the appointment of a director owes no duty to creditors of the company to take reasonable care to see that directors so appointed discharge their duties as directors with due diligence and competence. And then at G, sorry, you go to F. At F, he says the liability of a shareholder would be unlimited if he were accountable to a creditor for the exercise of his power to appoint a director and for the conduct of the director so appointed. But we say that that doesn't really take one anywhere, because any vicarious liability can be objected to on that basis. Then goes on, it's the interest of the shareholder to see that directors are wise and that actions of the company are not foolish. But this concern of the shareholder stems from self-interest and not from duty. So he's still considering whether there's some duty on the employer. Then there's a sentence from the International Tin Council case about privity of contract. And then he asserts at 221G, it does not make any difference if the directors appointed by a shareholder are employed by the shareholder and allowed to carry out their duties as directors while in the shareholder's employment. Now, that's correct. It doesn't make any difference to the question that Lord Lowry is considering as to whether the shareholder owes a duty to creditors or to the principles of privity contract. But that isn't addressing the question of whether vicarious liability should be imposed. Then he goes on at page 222, saying that assuming negligence, because these are assumed facts by
Sorry, where
August.
are you on 222?
I'm sorry, Melody.
On 222, where are you reading
Sorry, yes, first paragraph.
from? Thanks. In-house and August.
Yes.
Yeah,
If
in-house.
they didn't exercise reasonable care, which is the assumption, they may have committed a breach of the duty they owe to IACS, that's the money broker, which they were directing, a breach of duty they owed to the bank to exercise reasonable diligence and skill. These duties were separate and distinct and different in scope and nature. The bank was not responsible for a breach of the duties owed by House and August to AICS or to the plaintiff any more than AICS or the plaintiff were responsible for breach of duty by House and August. Now pausing there, of course, to say that IACS would not be responsible for breach of duties for the conduct of House and August as their directors is obviously a fallacy, and that was pointed out in the New Zealand Guardian case that we refer to, paragraph 81 of our written submissions, page 55 of tab 2 of the core bundle. So that's wrong, but perhaps more importantly is the bank was not responsible is either a conclusion from the previous reasoning that the bank didn't owe a duty to creditors, or if it's not that, it's simply a freestanding statement which simply assumes the question that is being asked. It assumes a negative answer to the question that's being asked. Well, what's the criteria by which the court is deciding that the bank isn't responsible? Well, one can see the criteria that they've used is a question of whether there's a duty to creditors. And that's got nothing to do with vicarious liability, where liability is imposed independently of any question of duty and independently of any question of fault. Then he goes on, this is between C and D. House and August were allowed by the bank to perform their duties to AICS in the bank's time and at the bank's expense. It was in the interest of the bank that House and August should discharge with diligence and skill the duties which they owed to AICS, but these facts do not render the bank liable for breach by House and August of the duty imposed on them by the trustees. In the performance of their duties as directors and the performance of their duties imposed by the trustee, House and August were bound to ignore the interest and wishes of their employer, the bank. We say, and again, that emphasises that the facts of Kuwait Asia are wholly distinguishable because the Privy Council are not addressing a situation where the employee did not ignore the interest and wishes of the employer. Now, we say Kuwait Asia wouldn't be followed today because it doesn't accord with BXB in applying the two-stage test. This is a question of vicarious liability. You apply the two-stage test. You do not start discussing whether the employer owed a duty to the claimant. But I say the facts are very different. Now, if I might then move on to the question of shadow or de facto director. Shadow director, first of all. Was Equity Trust a shadow director, namely a person in accordance with whose directions or instructions the directors of the company were accustomed to act? Now, on the judge's findings and the evidence, we submit there are three essential points that should have led to a finding that Equity Trust was liable as a shadow director. Indeed, they would have done so, but for the judge, but for the judge erring on the law and on his interpretation of the evidence. Now, firstly, the first of three, the judge accepted that Mr. Brown was sufficiently involved in all the decisions of Equity Trust that his dishonesty should be imputed to Equity Trust if Equity Trust were held to be a shadow director or de facto director. And that's paragraph 323. Paragraph 323, it's page 158, tab 7. Have that. The second essential finding is the judge accepted that in principle it was possible for Mr. Brown to take decisions in his capacity as an employee of Equity Trust, and in that capacity to give directions or instructions to himself and Miss Leonard as the directors of the claimant companies. And that's paragraph 301 on page 154.
Sorry, I didn't get the reference again.
I'm sorry. It's page 154,
Yeah.
paragraph 301. And the third critical finding is that the paperwork was all prepared ahead of time by Equity Trust, prepared ahead of any board decision. And we see that in the judgment. It's 304. Page 154. Judge says the administration team responsible for the particular company would prepare a board pack setting out the background, the rationale for the proposed transaction, and the supporting documents. And at 309, it just says, Mr. Parker notes that the directors were not proactive in the management of the company in question. For example, there's no evidence the directors instructed the administration team what to do. Instead, the evidence shows the administration team worked up a particular transaction and then presented it to the directors. And at 310, he says, while I accept that this is how the system worked. Now, on those three findings, the question arises then, why didn't the judge find that Equity Trust was not a shadow director? And he appeared to have two reasons for doing so, neither of which is consistent with the evidence. The first was that Equity Trust's administration team must be taken to have been preparing all the paperwork, not in accordance with directions given to them by Mr. Brown as a director of Equity Trust, but given to them by Mr. Brown as a director of the companies. And we see that, we're just looking at it, paragraph 310. The sentence continued without any independent thought. We come back to the question of independent thought. It goes on, in any event, he ignores the fact that Mr. Brown, for most of the period in question, led the administration team responsible for claimant companies. In that capacity, two roles. One was his role as employee of Equity Trust, responsible for the administration of the structure. The other was in his capacity as a director of the claimant companies. like all executive directors, it must, in my view, be the case that those decisions taken by him or instructions given by him as part of the day-to-day running of this structure, which are normally those expected of a director, must be understood as being in that capacity rather than as administrator manager employed by Equity Trust. Now, you'll note he says must be understood. He doesn't give any reason as to why it must be understood, and he cites no evidence in support. And it's also a rather odd observation about the day-to-day running of the structure when we're talking about the transfer away by a company of its sole asset. And we say the evidence is clearly contrary to the conclusion that the judge there states. The evidence, in fact, showed that the decisions as to what should happen were being taken by Equity Trust and not by the companies. The companies were carrying out Equity Trust decisions. And we say that is clear when one considers which of Equity Trust or the companies were taking advice as to what the companies should do. It was not the companies that took the advice, it was Equity Trust. The advisors advised Equity Trust and gave advice directed to furthering the interests of Equity Trust, who was the client of those advisors, so it's as you'd expect, rather than the companies. And thus we've seen Buckingham advising Equity Trust on Carey Street's draft accounts for the purpose of reducing Carey Street's profits. We've seen Buckingham advising on the transfer price with a view to saving tax, using a lower figure that might otherwise have been done. And of course, again, this is on the assumption that we establish liability on the part of Mr. Brown. The legal advice that was taken for the purchase of the properties and their subsequent hive-up was taken by Equity Trust and by Equity Trust alone. And that much is absolutely clear. Equity Trust insisted that it was the sole client of the lawyers and that the privilege in the advice was its alone. And there's an example from the Angel Miss proceedings, which we have in our additional documents Bible, tab 75, page 278. This is a letter from Rag Lawrence Graham, who were the predecessors of Gowlings, the solicitors for the respondents, which is addressed to the claimant solicitors who acted for Angel Miss Properties. And we see in the third sentence beginning, for the avoidance of doubt, the position of Equity Trust is that it was the sole client of S.J. Bowen at the relevant time. As such, Equity Trust has an exclusive proprietary right to the documents in S.J. Bowen's possession, copies of which you seek. Equity Trust rejects the assertion that Angel Mist has any claim of ownership over the documents, and Equity Trust does not consent to the release of copies of those documents to Angel Mist. Equity Trust's position has been made clear to S.J. Bowen. And indeed, Equity Trust then obtained the file from S.J. Bowen. And similarly, in these proceedings, in the same bundle, we can go to tab 7. Page 33. The liquidator of Carey Street sought documents from Equity Trust, and Equity Trust, and they were handed over. Equity Trust then accused the liquidator, of improper conduct. And this letter, tab 7, page 33, you see it's Equity Trust at the bottom left-hand corner, asserts privilege. We see this, page 35, middle of the page. You've asked us to identify the legally privileged documents. These are set out in the schedule to this letter, together with the basis on which privilege is claimed. Naturally, this list refers only to the documents included in the bundles accompanying the letters of demand. And then the documents in respect to which privilege is asserted, we see over the page are respect to the advice from DJ Freeman and Allsways. Now, such letters of advice or emails that were before the trial judge were there on an agreed basis, agreed in correspondence, that the respondents were prepared to waive privilege in those documents and only those documents and solely for the purpose of the hearing. So Equity Trust were absolutely clear that the advice that had been given to Equity Trust, the advice had been given to Equity Trust and not to the companies, and the advice, they were the sole client of the advisors. And indeed, it went beyond that. Now, obviously, you appreciate maintaining legal privilege against the companies involved asserting that the advice was confidential as against the companies. And we say it follows that the position of Equity Trust was that the relevant decisions were being taken by Equity Trust. No advice was ever given directed to what decision Mr. Brown ought to be taking as a director of the company. Therefore, it would be absurd to suggest that the relevant decision that the transaction should be progressed and the necessary paperwork prepared was taken by Mr. Brown as a director of the companies, rather than as a director of Equity Trust. The decision maker receives the advice. You don't give advice to somebody that's not making the decisions. Now, the judge addresses this point at paragraph 319 on page 157, tab 7. And we see what he says there. And again, that just doesn't do justice to the point I'm making. The advice was not how to administer the decisions that had already been taken. The advice was as to the decisions to take. And obviously, examples of that, we have the S.J. Bowen letter of the 18th of July advising Equity Trust on the transfer price. It's not an advice to 245 Blackfriars. And that's the advice that led to the board being instructed to transfer bankside estate properties at 148 million and 78 million, which they did. Now we say, therefore, that given that the evidence was that Equity Trust was taking the decisions, that should have led to a finding that Equity Trust was a shadow director. And that comes on to the judge's second reason for declining to so find. The judge appeared to think that whether Equity Trust had an expectation that the directors would simply follow direction or instructions from the administration team and sign whatever was put in front of them was relevant to the decision. But we had cited to him, and it's a principle that's not in dispute, so we don't have the authority. The relevant authority is Secretary of State for Trade and Deverell. It's 2001 Chancery Reports 340. And at paragraph 35, Lord Justice Morris says, quote, "It is not necessary to prove the understanding or expectation of either giver or receiver. In many, if not most cases, it will suffice to prove the communication and its consequence." So having concerned himself with what the expectation of Equity Trust was, and pausing there, we don't know who he had in mind. Yes, we have the authority here, perhaps I'll hand it up. So who he had in mind when he was talking about Equity Trust's expectation. In similar vein, the judge continued at paragraph 310. Going beyond simply asking himself whether the test for shadow director is met, and saying it does not follow that the directors, when presented with a proposal, would accept it without any independent thought. Now, the question of independent review, I'll be dealing with a subject to latitude being extended to me in a moment. But when we come on to that, we see that, first of all, the judge uses the word review. Now, in the context of shadow directorship, that appears to be a recognition that decisions have been made subject to review by the directors. So all matters had already been considered, and they'd been advanced to the point that they'd been recorded in legal documents that the board was simply being asked to sign. That's exemplified. Mr. Pollard's email, 31st of July, supplemental bundle, tab 6, page 54.
Oh, yeah. You absolutely have to finish by 1 o'clock. So if you've got time to look at this, then great.
Well, I'd better not look at any more documents then. I've got to do de facto and I've got to do the experts.
I'm afraid you do have to finish by 1 o'clock.
Right, okay. Right. Yes, well, all the evidence is only consistent with there being no worthwhile independent review. In that regard, we've got Mr. Brown. Well, he's been found liable for breaching his fiduciary duties. He has not exercised independent thought with respect to management charges and interest, as the judge has found. The judge relies heavily on a witness statement in the Angelmas proceedings by Miss Leonard. Now, Miss Leonard didn't feature, her whereabouts weren't known. But her evidence wasn't put in. There were statements against interest that we relied upon, but her evidence wasn't put in. And she had signed the misleading, dishonest minute with respect to the transfer of New Court. So it would be a little bit odd for the judge simply to accept what she says on this topic as gospel. But the essential point is that she made an assertion in that witness statement that she exercised, I think we've got the reference to skeleton, that she exercised independent thought and considered the questions in the interest of Carey Street. Now that assertion was obviously to mischaracterize what it is she was actually doing. Because dealing with the specifics, she says, I would always ask if professional advice had been obtained and was being followed. And she says, I wouldn't agree to it. For example, she says, if I was told that the advice was not being followed. Now, the advice, as we've seen, is advice that was being given to Equity Trust. It wasn't being given to the companies. So her concern, as an allegedly independent director, was really, she simply checked if advice which is directed to the furthering the interests of Equity Trust was being followed. So hers was simply a check that a decision that had been taken in Equity Trust's interests was being acted on in accordance with the advice that had been given to Equity Trust. And we know she didn't read any advice. There was no valuations to read. The legal advice was considered confidential as against the companies. As I say, so whatever she thought she was doing, she wasn't conducting any independent review. And therefore, the judge's reasons for refusing to recognise the position of Equity Trust as a director were fallacious. Now, de facto director, if Equity Trust isn't a shadow director, we then come and consider whether it should be said to be a de facto director. And the judge recognised that Lady Justice Arden had said one test is whether or not the defendant was the nerve centre. Now here, of course, we've seen the paperwork's all prepared by Equity Trust, the advice is all taken by Equity Trust. We said it's quite clearly the nerve centre. Now, the issue, therefore, we say the issue is who's making the decisions. Was it the Board of Directors or was it Equity Trust? Well, I've addressed you on that. The position with respect to the advice shows it's absolutely clear the decisions are being made by Equity Trust. And to that end, there's decisions made by Equity Trust. If there's no independent review, that's the end of it. But the independent review recognises that the decisions could be made to be provisional decisions. And if there's no independent review, because Ms. Leonard's just asking, has the advice given to equity trust being followed, that's not an independent review. And there's reference to, oh, well, Mr. Halibi wasn't said to be a shadow director. Well, there was no suggestion that this was a sham trust. The trustee was making the decisions. Everybody proceeded on the basis that Mr. Halibi and Buckingham were simply advisors. And therefore, final observation de facto, given the time, is paragraph judgment is 321 of the judgment, tab 7. This is Mr. Norbury submitting that Mr. Brown at no point removed his equity trust hat, as Mr. Norbury observed. Such a finding would be unrealistic and artificial. To treat equity trust as a de facto director of a company through the attribution to it of the actions of a person who is in fact a director of those companies simply makes no sense. Now we say this exhibits a confusion of thought, because we're not here talking about vicarious liability. One is not attributing the action of Mr. Brown as a director of the company to equity trust. One is concerned with the action of Mr. Brown as a director of equity trust in deciding to proceed with the transactions without getting an independent valuation, and instead to use a figure influenced by tax considerations. The decisions are being taken with advice owned by equity trust. Mr. Brown's taking that decision, therefore, with his equity trust hat on. The decision taken by him with his equity trust hat on is then made before the question of any review by the board arises. Mr. Brown is being sued as a director because he knew he could not know the market value without an independent valuation. Equity trust is being sued because it decided the company should proceed without an independent valuation, knowing that HMRC were to be misled. So Mr. Brown's liability as a director should not absolve equity trust from being liable for the decisions it took. Now, at 3 minutes, or 2 minutes, the position on the experts we've set out in our skeleton argument, it's really a very simple point. Mr. Manley took account of the development potential of the property, which he thought was a real positive. He said he would have given the same yield as Mr. Whitfield, but for the development potential. The development potential, as recorded in Mr. Manley's report, was recognised at the time. He cites from the reports that were given at the time that show that this was recognised as being an attractive feature of this property. In contrast, Mr. Whitfield, he proceeds as if it had no positive development potential. Now he says, I can't assess the development potential now in 2023 in the way a purchaser would have done in 2005. But instead of reaching some sort of halfway house, he then proceeds as if it didn't have any. So he makes negative, deleterious adjustments to the yield, average yield in respect to midtown properties, based on the age of the building, which would be relevant if it's to be redeveloped, and the fact that the term is coming to an end in six and a half years, which again is irrelevant if it's an attractive development property. And of course, he starts from the average of midtown properties, which is of all properties, irrespective of their development potential. So that's the critical.
Attention, please. Attention, please. This is the Incident Control Officer. A report has been received of a suspected fire in the main building. This is being investigated by the security fire team. All fire evacuation and first aid officers to alert status. Please stand by for a further announcement and obey the instructions of your local evacuation officer.
We may be all...
You'll also arrange that, haven't you?
We may
Attention,
be all right,
please.
or we may not be all right.
Attention, please. This is the Incident Control Officer. A report has been received of a suspected fire in the main building. This is being investigated by the security fire team. All fire evacuation and first aid officers to alert
I
status.
think the best plan is if we come back
Please
at
stand
5
by
to 2,
for further
and then Mr.
announcement
Parker, you can
and
have the
obey
final
the
5
instructions
minutes
of your local evacuation
to
officer.
raise that.